Please be seated. We'll hear argument in 23-282, Save Our Springs Alliance versus the Texas Commission on Environmental Quality.
May it please the court, Mr. Bunch will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, petitioner Save Our Springs Alliance is a nonprofit conservation organization working to protect the land, water, and wildlife of Central Texas since 1992. We seek judicial review of TCQ's final agency decision granting the city of Dripping Springs a permit to discharge over 800,000 gallons per day of treated sewage into Onion Creek, a short distance upstream of the RM-12 bridge in northwest Hays County. At the regulatory low flow conditions and full use of the approved permit, this classic hill country limestone stream would be converted into almost 90% treated sewage and only 10% natural creek flow. The approved permit was overruled on appeal by the Travis County District Court and then reinstated by a 2-1 decision of the El Paso Court of Appeals. In this case, TCQ made 3 overlapping errors of law, each rendering the agency's decision invalid.
I mean, is your argument really more of a factual question in terms of, you know, how much it was decided that the quality went down, you know, whether or not it was de minimis or whether it exceeded that amount?
No, Your Honor, we are definitely not raising any factual issues. All of our claims are errors of law.
Explain that to me in terms of this issue about whether it was a de minimis reduction, or as I understand it, your argument is that it was more than that and therefore more had to be shown.
Yes, we have accepted the evidence that's undisputed that the baseline conditions in this crystal clear hill country stream was 6.44 milligrams per liter dissolved oxygen up to 10 or higher. And that it's also undisputed, it's in the record, that it would drop it down from that 6.44 milligrams per liter or higher to right at or even below the minimum standard of 5 milligrams per liter.
Isn't that a factual issue, how much it would go down?
It's a legal issue. Your review of the case, it's a legal issue if that's more than de minimis, and under the APA, if they even documented what they based their decision on. In the final order we have here, there's no finding of what the starting level was. There's no finding of what the concluding level was. And there's no application of this mandate of no more than de minimis lowering of water quality to that drastic change from that very high standard to the bare minimum. And those are legal issues based on agreed facts.
Are you including the PFD and everything in it as part of the final decision or not? That includes at least a record that...
The PFD is referenced in the final order, but I believe this court has said, and I'm not remembering the case, that the APA is specific, that you have to have conclusions of law, underlying findings of fact, and then ultimate findings of fact. And that what we're challenging here is there's not a single finding of fact or conclusion of law applying this Tier 2 standard and even using the words no more than de minimis lowering of water quality. And our position is that there's an obvious reason for that it could never meet that standard if you actually quoted it, had a conclusion of law that said what it meant, and then applied it to the facts.
I guess why I was asking that is, as I understand it, and obviously you all understand a lot better than certainly I do, but the idea that it could drop to 5 milligrams per liter at the point of discharge briefly and then almost immediately be restored to the pre-existing level of dissolved oxygen. Now, if that's true, that seems, as Justice Lehrman was suggesting, there's a factual question about how quickly that happens, when it happens, and at least as I read it, it seemed as though this
Right.
very lengthy document was saying, maybe not with the specificity that you would like, but that
Right.
we've concluded that Tier 2 is satisfied, that these amounts are not going to be dropped, the water quality won't change. And so if it really amounts to the word de minimis not being used in this particular document, that's an argument, I guess, but is that what it reduces to, or is it the question about whether or not there is a basis in the record for thinking that the 6.44 would be retained, but maybe not right at the point of discharge?
So the agency's rules make very clear that at a discharge that's less than 1 million gallons per day, there's no mixing zone. And so it has to meet the standard and be judged on compliance at the point of discharge. So even though it does, you're correct, it recovers further downstream with mixing and aeration with flowing and riffles. That is not relevant under the law. But again, whatever the court thought, whatever the agency thought about that, had to be in findings of fact and conclusions of law, and we don't have that here. And that's what the APA, the plain language of the APA calls for, and what this court has called for 29 years.
So that's really your argument, is just that the findings don't support the conclusion, right?
That there's no findings
Yeah, that's what I mean.
and no conclusions of law that quote the rule. And as Professor Beal has,
I mean by conclusion, allowing the permit.
right, you can't apply the law if you don't even quote it.
But you said when you started off that your side accepts the undisputed facts.
Correct.
That you have 6.44 up to 10 at the top and then down to 5 or 4.79 or whatever that
Right.
number was
Right.
at the bottom. Where are those facts in the record?
Those are in the record in multiple places. Respondents have never challenged that this is like undisputed in the record.
And your
That
point-
variance
Your point
happens.
is that had to be stated as an official finding of fact in front of the agency proceeding?
Yes, because maybe the agency would said, well, a 6.4 is a little low, that background is actually higher. And then what is the end point, post-discharge? Is it just below the 5 milligrams per liter? Is it just barely above? And that was the entire range of the evidence was, tiny amount.
Well, why do you need a fact finding if it's undisputed? You said it was undisputed and you accept it. So, you would never submit it to a jury for a fact finding if it's undisputed. Why should it have to be stated in some particular place?
So that this court can exercise the judicial review that it's called for.
Well, we can take the undisputed facts that you say you accept.
I guess, Your Honor, I would go back to, your charter medical decision, which says you have to decide it. And especially like you have a range, there's a little bit of difference. What are they finding that it is? And then go to the next step.
But I thought
And
you said
comparing the two.
that what they're finding and the range is undisputed. I thought,
The range is undisputed, correct, but then there's never, okay, what is the comparison? And the agency's guidance and the EPA guidance as well says very clearly, you can only have a tiny drop. And the guidance suggests it can be less than 0.5 milligram per liter before you go beyond the more than de minimis standard. EPA suggests 10%.
On the EPA suggestion, does it make a difference that the EPA withdrew any objection that it had to this particular permit?
Your Honor, we say
In terms of
absolutely.
saying
yes.
whether or not the EPA guidance should come into play?
No, we believe that's a misleading argument from respondents in that EPA has limited resources. They withdrew that objection. I mean, it's incredibly rare that they even make an objection, but they withdrew that before they ever heard any evidence or argument of counsel. And these cases have to be decided on the record in the contested case hearing. So That is not a decision of EPA that is appealable or even relevant. We don't know why they withdrew the objection,
Well,
but
they
we
said
know
they-
that
they
it
said
wasn't based on
Counsel,
the
they said they
evidence.
withdrew the objection because they were satisfied.
They were
They looked at
satisfied.
all of this material that had been done, all of the detailed answers.
Right.
They looked at the record materials that are part of this record, and they said, all right, our objections are satisfied. Didn't they literally say that?
I believe they did along those lines.
So we
But
kind
again,
of know why they withdrew their
well,
objection.
they did not hear the evidence.
They saw a lot of the evidence. That was a lot of the evidence that's including in the PFD was what was presented to the EPA, as I understand it. Now, if you're telling me that's wrong,
That
and they
is
just did
not-
it by
yes.
flipping a coin, is that what you're
Yeah,
saying?
no, that's not correct, Your Honor. That the evidence that was entered into the contested case hearing was lengthy and detailed with science in great amounts. And the EPA's withdrawal was way before we got even close to
But
a hearing.
why does the EPA have to wait until that point? It is not the adjudicator. It is someone who could object, and it decided based on what we're seeing, we're satisfied. I don't understand.
Well, Your
why
Honor, we're
it's
not saying
relevant
they,
that-
we're not saying they have to
Counsel,
wait.
Counsel, what I'm trying to find out is why it matters whether or not EPA waited until the end of a hearing, when the question is, EPA, as someone who clearly is capable of participating and did so, saw enough information that was presented to it after study to say, we don't need to participate anymore. Why would EPA have to stay? It's not the ALJ or something, it's not the commission.
Yeah, we're not saying they have to wait. What we're saying is what they said was irrelevant to the issues because it was not informed by or engaged in the contested case hearing where the evidence was admitted. And what the APA says the decision has to be based on.
You said at the beginning you had 3 errors of law you wanted to tell us about. I'll invite you to do that.
Yes, Your Honor. Thank you. The first one is just that had they applied the rule, the plain language of the rule, I mean, de minimis, this is going to Justice Scalia in the case we cite, the Amici cite, de minimis is not Latin for close enough for government work. The courts have recognized and EPA has accepted a de minimis exception being included in state rules, even though the EPA rule that sets the bare minimum and that the interpretation of our rule must comply with, they've allowed it. But they've said this has to be narrowly confined. It has to be trivial, trifling, of no moment in the law. That's the Black's Law Dictionary in plain language.
Is de minimis here being used as a legal phrase or more to indicate the margin of error for these dissolved oxygen levels that can vary according to the conditions of the flow of the river? And, on any given testing day, the test results may vary. And is it really trying to get to the margin of error in connection with measuring dissolved oxygen as opposed to a legal principle about, close enough?
Your Honor, we would disagree with that. And I believe the science is pretty strong and they can make these predictions. And we know exactly what the permit allows in the effluent. We know we've measured what's in the creek. And then you just mix the ratios and you can calculate it with some great degree of accuracy. What we do know, though, is that this agency has never found a discharge into our highest quality waters of the state of Texas. And we have those, as Amici has laid out, from the plains and mountains of West Texas to our coastal bays and estuaries, from the forests of East Texas to the hill country and the cross timbers. These are classic, iconic waters that are critical to our state, and they're dwindling and degrading because they refuse to apply this absolutely critical rule that is a fundamental cornerstone of the Clean Water Act. It's every bit as important to the Clean Water Act jurisprudence as the issue that the U.S. Supreme Court, which we would urge you to follow, in the 2019 landmark Clean Water Act case of County of Maui versus the Hawaii Wildlife Fund, where in the majority, with a concurrence penned by Justice Kavanaugh and citing back to a previous Clean Water Act case penned by Justice Scalia, said that we are not going to defer to the EPA's interpretation of the law, where it's creating a giant loophole and facilitating evasion of the law. The purpose of the Clean Water Act is to maintain the quality of our waters, the chemical, biological, and physical integrity, and restore our waters. And a lot of the focus has been cleaning up our polluted waters. And the agency now, for decades, and literally they can't point to a single case where this tiny little exception of de minimis has ever been exceeded. And you have a case here where refusing to apply the rule is resulting in this very tiny, trifling exception literally swallowing the entire rule.
But did
And
they
so
not
our
make,
high-quality waters are being degraded.
Did they not make a substantial reduction in the initial proposal so that what the city was asking for is not what they got from TCEQ? Is that not correct?
Well, they reduced the volume a tiny bit because their DO modeling was showing they were going to violate the DO standard.
So I guess the question is, we're trying to figure out not if the agency is just ignoring the law, but how they're applying it. And that's the question. What are the factual underpinnings of that? It seems at least possible that that reduction, characterize it however we will, was designed to actually achieve this very thing. It's not that they're ignoring it necessarily. I'm not disputing necessarily that they are. It's your argument.
Right.
But one reason maybe that we're not seeing, this de minimis thing being exceeded is because they will only grant the permit if the changes are made in order to actually follow what the law requires.
Right. Thank you for that question, because that lowering, reducing that volume to meet that DO standard, that is the minimum dissolved oxygen to avoid harming aquatic life. And that's the minimum standard in the Tier 1 rule that says you have to protect aquatic life uses. And the record again is here clear, and you actually have respondents arguing that we only have to do Tier 1 when we look at dissolved oxygen. Their experts didn't even look at that difference in the drop. And in fact, the city's expert, Dr. Mirchin, said it's irrelevant. And so this is where we are today. The agency has written out of the statute this critical protection of our highest, most beloved, most iconic waters across the entire state. And one of the ways they're doing it is refusing to even name the rule. This is the rule that shall not be named. If you name it, you explain what it means, then we submit respectfully you have to reach a different conclusion.
Your time has expired, Mr. Bunch. Are there any other questions?
Thank you.
Thank you. We'll hear from the respondents.
May it please the court, Mr. Kraft and Mr. Tuckfield will present argument for the respondents. Mr. Kraft will open with the first 10 minutes.
Thank you, Mr. Chief Justice, and may it please the court. Of the arguments for reversal that you've heard today, I plan to address two issues. First, why there's no controlling federal law that the Commission failed to follow in its order, and second, why there are no required underlying findings of fact that the Commission failed to make in its order. Mr. Tuckfield will then address why the Commission's order complies with the anti-degradation rules. So starting with that federal law, you heard Mr. Bunch refer to EPA guidance. And there are certain things that EPA considers to be degradation. We know that that is not binding on the Commission from the memorandum of agreement that the Commission entered into with EPA. On page 1, it says that TCEQ must take into consideration published EPA policy. That's not required to follow. And when EPA approved Texas handling this program back in 1998, it said, and I'm quoting from 63 Federal Register 51188, although for the sake of national consistency, EPA strongly encourages states implementing a NIPDES program to do so in accordance with EPA policies and guidance. There is nothing in either the Clean Water Act or 40 CFR Part 123 that requires them to do so. So what TCEQ is required to do is to follow the EPA approved rule and the EPA approved implementation procedures, the IPs, which explain how to apply that rule to a permit application. Now, Mr. Bunch says that in this case, the commission did not apply those rules correctly and the IPs correctly. But again, EPA didn't think so, and this is for the reason that was discussed. EPA withdrew an interim objection to this permit in which it specifically asked about anti-degradation review and Tier 2. In
But
response,
at that point, the EPA didn't know what the ALJ's decision was gonna be and whether the ALJ would or wouldn't apply the rules properly, right?
it did not, and that's a function of the memorandum of agreement. If you look in the memorandum of agreement,
But isn't that the question that's in front of us, whether the proposal and then whether the action of the agency meet the requirements of the statute?
it is,
And
but
the EPA had no way to know whether that was gonna happen because it hadn't seen any of those things yet.
actually, the EPA did have a way to know. So going back, I think Justice Young already hit on this. EPA did have evidence that was in the contested case hearing.
So what, let's get into that then. So what evidence did EPA have on Tier 1 that granting a permit would sufficiently protect indigenous fish, shellfish, and terrestrial life?
So what was provided, and you can see this in EPA's letter on, which is attached to our brief on the merits at tab D. It said they were provided with the draft permit, the technical reviews, the statement of basis, and the technical summary. All that was evidence in the contested case hearing.
But we don't have a finding from anybody that the permit would sufficiently protect indigenous fish, shellfish, and terrestrial life. So what evidence is there?
Well,
Was
you
it
do-
required to have such a finding under Tier 1, and if so, what evidence?
You
Could
do
we
have
just imply it?
You do have findings that Tier 1 was satisfied. All the anti-degradation findings are fact are all at findings of fact 67 through 91.
Well, the
in the
ALJ
order.
seems to have thought that Tier 1 was satisfied if any aquatic life uses were protected, but doesn't the guidance require indigenous life to be protected?
No, what the guidance requires is, if you look at Rule 30710, and at Appendix A, that breaks down all the waters in Texas that have been classified by river basin. And you look at the Colorado River Basin, you look at segment 1427, which is Onion Creek. That has the uses that are designated, and it's the first few columns talk about contact recreation, aquatic life, public water supply, other uses. Next to that, there are several columns that have the criteria that are required to be met to sustain that life. And for dissolved oxygen, it's 5.0. And here, the aquatic scientist, Lily Murphy, who performed this analysis, found that would be satisfied.
Okay, but doesn't it, so there's not, it's incorrect to say that there's a TCEQ policy that says the question on existing aquatic life uses is whether granting a permit would sufficiently protect indigenous fish, shellfish, and terrestrial life?
I think you're quoting the rules, so that is part of it.
Okay, so does a conclusion or a finding that it might support other kinds of fish or algae, does that satisfy the indigenous part of the standard?
No, that's not part of the analysis.
Okay, so the ALJ's wrong then on.
No,
on Tier 1.
I don't think I'm understanding what you're referring to, but if you're talking about was the IP that requires looking at that dissolved oxygen level to sustain the aquatic life uses that are in the rules, that was done.
I don't know how else to ask it, but, okay.
All right, I do want to answer your question. I'm not sure.
I'm just wondering about if the conclusion is that it's gonna be above 5 and it's gonna protect greater species richness, does that really address the question about whether indigenous fish, shellfish, and terrestrial life will be
That may have been a comment that the ALJ made, but there's substantial evidence in the record to support that it actually does support the existing aquatic life, and that is what is required by the rules. So, I mean, if you find something in the ALJ's opinion that I think they've suggested, that's all this is based on. It's not. There is the water quality modeling that found that you would hit that 5.0, and that's what is required by the rules.
So I think,
Go ahead.
I read the briefing to say that tier two, there's recreational use, aquatic uses, and then there's sort of existing dissolved oxygen levels, which in some pristine waters is going to be a higher number than what's necessary to sustain aquatic life. And it sounds like their argument is that the commission conflated those two, and instead it should have required the preservation of this higher level in this pristine river, and not just determined whether or not it was adequate for recreational use and aquatic life. Could you address whether the commission improperly conflated those standards?
The commission did not improperly conflate the standards, and a couple of responses to that. First, both Tier 1 and Tier 2 require maintaining existing uses. So the relevant dissolved oxygen criteria for maintaining existing uses in the table I was just discussing with Justice Busby, that's part of Tier 1 and Tier 2. And the strategy by Save Our Springs has been to, every time there's a discussion of Tier 2, they will isolate this discussion of existing uses and say, aha, you've conflated the two. The commission did not conflate the two. They are both, existing uses as part of Tier 1 and Tier 2. So it is relevant to talk about Tier 2. Now, as to the question you asked about maintaining it at exactly the level it is, that is not what Tier 2 requires. Tier 2 is not an assessment of whether there has been a de minimis reduction in dissolved oxygen. Tier 2 is about whether there is no more than a de minimis lowering of water quality. Dissolved oxygen is only one part of that. And if you look at Tier 2, if you look at the IPs, and this is, I'll give you the record site. This is document 257 in the administrative record. The Tier 2 implementation procedures start on 61. It is looking at everything. It starts by saying, here's the parameters of concern you need to look at. There's 15 things, including a catch-all. And then it goes on to say that you compared, you do a screening, you're looking at baseline conditions that are established in the Texas Water Quality Inventory, which Ms. Murphy did, compared to the effect of the discharge. You're looking at this as an entire water body. That's what was done in this case for the lowering of water quality piece of Tier 2. And so you do not myopically isolate dissolved oxygen and say, if there's been some X number of delta for dissolved oxygen, then you've blown Tier 2. You have to look at everything. And that's what.
So are you saying that going from 6.4 to 5, that's right, but that's okay? Or are you saying that it's not actually happening, or both?
I'm not saying that's not actually happening. I mean, the modeling suggested that there would be, the effect would be a lowering of dissolved oxygen to that extent.
At the point of discharge, or more broadly?
At the point of discharge. It does not mean that there is a lowering of the entire water quality of this entire water body.
Your friend on the other side says that the law requires us to only focus at the point of discharge. Is that correct?
I believe that's what the modeling.
And so if that's so, again, to someone who's not an expert in this area, and I understand your point about, well, it's this general thing, but there surely is some force in the other side's view that just talking about general water quality, which is awfully vague and amorphous, is one thing, but when you actually see a pretty substantial drop in dissolved oxygen, which seems to be an awfully important thing, just to say, well, no big deal, that sounds like degradation, is what it sounds like.
It's not that it's no big deal. It's that you don't look at a single parameter and say that has blown the entire water quality. And so for something like dissolved oxygen, for example, the issue with dissolved oxygen is that you need dissolved oxygen to sustain the life. And so that's what that 5.0 is getting at.
So in terms of then the required findings, I guess maybe you can tell me what is it that I can see in which the commission says, all right, yes, it's dropping this much, here's why, that is something that is not a problem for tier 2.
So,
Is it what you just told before, document 257, starting at page 61, or something else?
well, those are the IPs. Those are the
IPs, yeah.
IPs. If you want to look at Ms. Murphy's application of those IPs, her testimony is in the record. But as to whether there has to be a finding that mentions 6.44 to 5.0, no, there doesn't have to be, because what they're referring to is section 2001-141D of the APA, which says that when there are findings findings in statutory language, there has to be findings of underlying fact to support those. The anti-degradation rules are not in a statute, they're in a rule. And this was, I can't explain it better than Justice Goodwin did in her opinion for the third court on remand from this court in the Maverick County case. The language is in a rule, not a statute, so it doesn't trigger that requirement for underlying findings of fact. But there is substantial evidence in the record to support finding of fact 90, which says there will be no significant degradation of water quality, which is what Tier 2 requires.
Any other questions? Thank you, Mr. Kraft. Mr. Tuckfield, we'll hear from you.
Thank you, Mr. Chief Justice. May it please the court. I will address the collapsing argument, the question of whether Tier 2 was done, and the 4.87 milligram per liter argument. But there's a number of questions that came up that I wanted to make clear. When TCQ issued this permit, they did reduce the phosphorus limit, not just the amount, but the phosphorus limit. The city asked for a 1.0, they reduced it to 0.15. This is how TCQ does this process. And that assured that there would be no degradation. We also talked about
Did the reduction come after the water quality studies were done, and were they reconfigured to show what it would do to water quality based on the proposed TCEQ reductions? And what's the timing on that?
So what happened is that the city submitted its application, TCQ did its technical review, did that technical analysis, and determined that the phosphorus level was too high, that what the city was asking for, so it needed to lower it. And then that's when they issued the permit. But they did additional research, and their technical memorandum supported the lower limit for phosphorus. So they did reduce, so what's happening here is that TCQ is not just rubber stamping these applications. They're looking at the phosphorus, nitrogen, DO, and looking at how all this applies. Now DO, dissolved oxygen, is a very interesting parameter because phosphorus and nitrogen is not a numeric number. DO is actually a numeric number, and Mr. Bunch says that they only applied tier 1, but that's simply not true. The rules specify that DO is determined by looking at Table 3 of Appendix A of the Texas Surface Water Quality Standards. It is a numeric number, and it's important to realize that DO is dissolved oxygen is much like if you go to the emergency room at a hospital, they put a blood oxygen level on your finger. You're at 99. Well, that's fine. Well, how about 10 minutes later, you're at 97? Well, that seems like a big jump. You went down to 97, but that's still fine. It's all, and 94 is fine. Now, when you get to 89, now the doctors are starting to get worried. So DO, just because you went from 6.44 to 5.0 at some point, by the way, it comes back up, but just because you have what looks like a big jump, that doesn't necessarily mean it's bad. It doesn't mean...
But isn't that the point of Tier 2? I mean, Tier 1 is whether it's sufficient to protect existing uses, but then Tier 2 is about preserving the waters that exceed Tier 1 quality and maintaining and protecting those,
Absolutely.
right?
It's water quality, though. It's not a specific parameter, and that drop in DO does not change the water quality, okay? Just as a blood oxygen level from 99 to 97 in your own body doesn't change.
And is that because it protects existing uses, or what's the reason that it doesn't?
Existing uses, but plus everything else.
Well, it can't be existing uses, because we've already talked about that in Tier 1.
Oh, but the rule, if you look at the tier 1 and tier 2 rules, both address existing uses. So tier 1 and tier 2, tier 1, you have to analyze whether water quality can be lowered by, you have to analyze whether existing uses are maintained. That's
Well,
tier 1.
but you also have to analyze whether it's necessary for important economic or social development.
No, only if there's an exception. Only if if you're
If
not
there's
applying.
degradation, right?
If there's degradation, yes.
Right.
But there's no degradation here. Degradation, remember, is defined as lowering of water quality by more than a de minimis extent. It's not looking at each parameter, it's looking at water quality in general. And these are.
But if you define de minimis by existing uses, then you never get to the analysis of whether it's necessary for important economic or social
I
development.
do not define de minimis by existing uses. Tier 2 is a two-pronged analysis.
I
One,
hope so,
you gotta-
otherwise there's no reason to do it.
That's exactly right. That's exactly right. You've got existing uses. Tier 1 is existing uses, right? That's it. Tier 2 is existing uses, but also you can't lower water quality by a de minimis extent. Tier 1, you can maintain existing uses and you can lower water quality by more than a de minimis extent. So they're overlapping, but tier 2 has a higher standard. It's much like if you were a frequent flyer and you've got the gold status, you get 7 benefits, right? If you got the platinum status, you get those 7 benefits plus 7 more.
Is the provision about important economic and social development at issue here at all?
It's not an issue at all because there was a finding of no degradation. If you found degradation, then that would be an issue. That would be
So
an
I
issue.
hear you saying that no drop in DO on its own could constitute degradation.
That's not true. Well, the drop, if you went
No
below
matter the
5
size.
if you went below 5.0, then
Right.
yes.
Okay.
You could have degradation.
But if you, what's the maximum DO you could have? I mean, could you have, in a really clean body of water, could you have DO more than 10 up to?
Sure. In fact, there's measurements in this body of water that exceeded 10. It varies over the year.
Okay,
It
if
depends.
you were at 20, if that's even feasible, and it dropped to 5, that in and of itself wouldn't constitute degradation?
I've never heard it as being as high as 20, but I'm not a scientist, so I don't know. 10 seems to be around 10 is what the highest I've heard of, but it's, again, it's like your blood oxygen level, 99 to 96, 99 to 94, you got everything you need in your
But
body.
you're going from the
river has
maximum-
everything you need.
You're going from the maximum. Justice Huddle doesn't, none of us know what that maximum is, but whatever it is, if you're at that, and then you drop to the minimum, you're saying that that's like going from 99 to 97 in blood oxygen?
5.0 isn't the minimum. 5.0 is the minimum to maintain the quality of the water.
Right, well, but that's where we're at
So,
tier
yeah.
2, I guess, so that is the
So
minimum, right?
2 is for tier 1, right? You can go down to tier 2 in Walnut Creek. This discharge, by the way, goes through Walnut Creek, then down to Onion Creek. And I think there was a misunderstanding in some of the questions I heard earlier. The actual discharge point, the requirement is 6 when it discharges, and then it goes through Walnut Creek down to Onion Creek. And where you get the 5 is right where Walnut Creek dumps into Onion Creek.
That's the point, okay.
That's where you get that minor.
Why not try and get a finding about necessary for economic and social development? If, you know there's a fight about what counts as degradation, and that's gonna be an issue. It seems like, all of this is sort of a balancing between necessary economic and social development and everybody's desire to have clean water. It seems to me we ought to be talking about that. That should have been litigated. Why isn't that part of this case?
Because there was no degradation. There was a finding of no.
Well, they're arguing that there was, and they have been all along.
Sure.
So it would seem to me that you would want to have the finding about economic and social development as sort of a backup.
It could be a backup, but it's not required in this case. And let me point out that the city has entered into private settlement agreements with numerous protestants, LCRA being one of them, where they committed by contract not to discharge for the first 399,000 gallons per day will be zero discharge, and it's enforceable by contract. After that, they've committed to, in these contracts, to, if there ever is a discharge, that there's going to be, there's a penalty provision there's a potential penalty provision where the city has to build additional beneficial reuse facilities. We've got a golf course right now in Dripping Springs that is irrigating with potable water. And it's just a waste of potable water. They're dying. They're begging to get the treated effluent that we have, that we're ready to send them. The easements are already being acquired, and the construction, we have ponds, and we want to send this treated effluent to that golf course.
So you said in response to one of the questions about if it went from the maximum of dissolved oxygen to 5, that in some cases that would be degradation, and in other cases not. Can you explain that?
No, I said if it went below 5, it would be degradation, but the
So there's
tier
no
2
case
rule.
where it would ever be degradation to go from whatever the maximum dissolved oxygen is to 5.
It depends what segment you're in. Okay, tier 2 tells you to look at the segment. We're in segment 1427, and that segment says what you need to maintain water quality in segment 1427 is 5. A different segment may have a different number. TCQ has gone through all this analysis. They've done all the scientific research. They've determined what the dissolved oxygen needs to be for that segment. It's water body specific, and TCQ has figured this out scientifically. And the court shouldn't say, well, even though you determined scientifically that 5 is what you need, well, 6.44 to 5 looks like a different, looks like a lot to me.
Is there a case or a statute or a regulation or something outside of the table that we should look at to support your argument on that, or is it just the table?
May I continue?
Yes, may.
The Robertson case does that, but the statute 307.5 is also very relevant in this question, because it literally tells you that tier 2 for dissolved oxygen is determined by looking at this table. I mean, that's a regulation. I don't know if I said statute. I meant regulation if I said statute.
Any other questions? Thank you, Mr. Tuckfield.
Thank you.
Mr. Bunch, you have 5 minutes.
Thank you, Your Honor. Let me start near the beginning there, where opposing counsel said that for tier 2, you have to look at everything. That's one point we have an agreement. But what he then went on to suggest, and they've argued before, is that if you look at everything and some of it's staying clean because there's tight restrictions on the quality of effluent for that particular parameter, while another one is dropping down to the bare minimum, you can still conclude that, oh, you're protecting water quality, or you're not lowering water quality. That is not the case. You have to, and the law is overwhelmingly clear on this, that you have to meet the anti-degradation rule, tier 2, tier 1, on a parameter by parameter basis. And you can find that it violates it on one but meets it on another.
And what's the best authority for that?
Pardon?
What's your best authority for that?
Well, the Kentucky Waterways Alliance versus Johnson, which is a Sixth Circuit case, the Ohio versus EPA 10th Circuit case, and then the Ohio versus Shank, Columbus versus Shank, Ohio Supreme Court case. All are looking at exactly this issue and are reaching the conclusion that the agencies there are doing exactly what the justice suggested. We're conflating this higher, more protective standard that is only there to protect our highest quality waters with the bare minimum, tier 1, much more lenient standard. And you cannot do that because...
Well, I think they said tier 1 would be 2 milligrams, right, not 5?
That is not correct. The 5 milligram numeric criteria is set at the level to protect the aquatic life uses. That's how it came up with 5. And that's what it means. And so tier 1 and the numeric standard merge at that. But tier 2 says if you're up here, you got to stay up here, or you got to stay really close to that, unless we do what the rule calls for. If there's special social or economic needs, you make that showing, because we don't want to have, the concerns that the home builders assert, that, we're not going to be able to build housing. But thankfully, in this world we live in now, as Mr. Tuckfield just said, there's a high demand for this effluent. It can be treated to very high standards and then reused, either potable or non-potable, both. And that gets us to the Clean Water Act's goal of eliminating discharges. And that's where the agency is required to be headed. And instead, what we're seeing is they're rubber stamping and feeling like they have to issue every single permit. And one way they're doing by that is evading the application of this clear rule. Yes, both Tier 1 and Tier 2 say you have to protect those designated uses. But Tier 2 goes higher and says you have to protect it up here. And EPA tells us, the case law tells us, if there's more than a de minimis drop from that baseline condition for any parameter, including especially dissolved oxygen, because the fish and the other critters need to breathe just like we do, that minimum drop is more than de minimis. And we have to enforce.
Is that the big difference? I mean, they say, no, it isn't parameter by parameter, it's water quality. And you just said, no, if there is a drop even in one, even if it's not going to affect overall water quality.
Correct. And if you look at their own IPs, it's parameter by parameter. If you look at the permit, it's parameter by parameter. And if you look at the final order and its findings and conclusions that are there, albeit inadequate, it's parameter by parameter. And that's the analysis.
I can get that you would examine parameter by parameter in order to do the study, but in terms of the conclusion, the bottom line conclusion, is it that the whole thing will fail if even one parameter drops? That's the part, I guess, that really divides.
Yes, you have to keep it clean for all of these key parameters. Otherwise, one really nasty thing that matters, and dissolved oxygen is kind of important. It doesn't really matter if the other ones are kept clean, but some particular elements are causing degradation of that high quality.
And you mentioned the federal and Ohio cases and the IPs, but are there any Texas cases that address whether Tier 2 has to be parameter by parameter, or is there anything in the statute or the rules that you'd point us to on that?
The IPs and the EPA guidance and the final rule, but no, I'm not seeing a case. The Robertson case does say it follows the right analysis. You look at baseline, you look at post-discharge, and you compare the two. That was not done here.
If the question were, is there substantial evidence in the record to support the conclusion that water quality is not degraded, aside from the parameter by parameter, some of which I get it, like if it gets below 5, I think even they agree, that's sort of an automatic exclusion. But if that's the question, is there substantial evidence to support this bottom line conclusion about water quality? What is the answer to that question?
Well, our answer would be that is too vague in general, and then, everything, they can just rubber stamp everything, and the whole judicial process is roughly.
That sounds like you're wanting to change a lot about administrative law and not so much just say that this was done differently.
We are wanting to implement the rule that's in place as it's written, absolutely, and they have been the ones to dodge it and refuse to apply it. If I may make one last point.
You may.
I see my time's up.
You may.
On our APA argument, we are asking that you overrule that part of the Maverick County Third Court decision on remand that says you don't have to have underlying findings of fact. Let me start with, first, there's a fundamental error of there's not proper conclusions of law. Then for DO. There's not proper, and for the rule itself, what does the no more than de minimis rule actually mean? Tell us in a conclusion of law. Then there's no underlying findings of fact as to DO ultimate findings. The rule here, and this is where the Maverick County got it wrong, is this rule is in statutory language. And in fact, it was embedded and incorporated into the Clean Water Act by the 1987 amendment that's at 33 USC 1313 D4B. This is in our response brief. And both the Clean Water Act and 2603, the Water Code, say you have to maintain water quality. And just because you change the wording, and this is in charter, instead of saying maintain water quality, you say don't lower water quality. You can't get around that mandate for underlying findings of fact that can demonstrate reasoned decision-making just by clever wording. And we submit that we should prevail on all three being inadequate under the APA and the charter medical test.
Any other questions? Thank you, Mr. Bunch.
Thank
The case
you.
is submitted, and the court will take another brief recess.
All rise.